Hello and welcome to the Good Governance Academy webinar. It's actually just not one of our 1 hour long webinars. Today is our 15th colloquium. So it's a very special welcome and we have very special guests online today with us. So welcome to everybody. For you who, if this is your first event with the Good Governance Academy, we are really an organization that amplifies the voices of others, and we focus on matters of critical business issue and matters that really have an impact for most businesses around the world. And we have a big audience that follows these webinars and events. They are all free to attend, and we have thought leaders providing us with really insightful content, and we have online participants, our attendees. Welcome to our community. We have lots and lots of discussions in the chat function. So the chat function is open today. If you can't see your function buttons, just click the Alt key on your keyboard and you'll be able to see the function buttons. So please use the chat function, communicate, introduce yourselves. Let us know where you're from. I see Rolf there from Windhoek. Welcome. Let us know where you're from. We have 81 countries that have registered to attend this webinar. Last year on our events, we had 143 countries and 21,000 unique people had attended our events in 2025. So welcome to everybody. We've got about 1,500, 600 people who have registered for this event. So we are going to have lots of engaging discussion with the content, about the content, with everybody online in the chat function. If you've got a question for the speakers, for the panelists, please do put it in the Q&A function, because with all the chat going on the chat function, we're going to miss your conversation or miss your questions. So please use the Q&A function. We've also opened up the closed captions with translation. So if English is not your first language, please, or if you're not understanding one of the speakers clearly, please do use the closed captions. They are very useful to follow along in terms of what people are saying in your language, the language of your choice. If you are wanting to react to what's being said, if you're excited, if you are happy, if you love what's being said, please do use the reaction buttons. You'll see can you find the yes, there we go. Somebody's found the reactions. Please give me a thumbs up if you can see the reactions. Find that. Excellent. Thank you so much. And for those people who are looking for certificates of attendance for CPD purposes, please, you must indicate your participation in the webinar. And as such, we will be launching polls during the webinar. And in those polls, you must please respond. If you can't see the poll, we will put it in the chat function as well, in case you're using your phone, for example. We will put it in the chat function so that you can respond to the poll in the chat, and we'll still pick that up, that you are participating. It's not about your attendance, and this is a requirement from the professional bodies that use our events for continual professional development and continual professional education, CPE purposes. So especially for those attendees today who are SEMA or American-based organizations, some designations from the US, the CPE requirements require that we do ask these polls and we have you participate. So thank you so much for your attendance and attention to this issue. We do need to make sure that we are credible in our issuing of certificates of attendance. So I'm not going to take up much more time because I see that we've got lots and lots of people online. Thank you so much for letting us know where you're from. Please, if you would like to share your LinkedIn profiles, have people connect with you, that's also most welcome. I would like to kick off now that we've got 500 people online. So I'd like to kick off by asking our founder and our patron, Professor Mervyn King, who's been involved in this subject matter for many, many years. So I'd like to ask Professor King now to open our 15th colloquium. Thank you so much.
Thank you, Karen. Well, good day to everyone, seeing we are in different time zones, most of us online. But today is an important one, in my judgment, because it will bring to the highways of the minds of people around some 167 countries when we, the Good Governance Academy, summarize what the speakers are going to say and the panelists, and send those summaries to our support members who send it to their members. And it will reach 4.5 million professionals, directors of companies and great corporations from around the world. So if the concept of an international anti-corruption court wasn't known before today, by tomorrow it will be known about. And hopefully many of them will read the excellent draft which has been established for as a statute for the establishment of the International Anti-Corruption Court. And a special thanks to the penholder, Judge Susan Lamb in New Zealand. Well, corruption is an evil that harms mostly the impoverished, rather than that impoverished person's fellow citizens. This is so because kleptocracy, where heads of state and other senior officials loot public funds which are intended to alleviate the suffering of the impoverished in countries around the world. This looting is driven by greed, self-aggrandizement, and self-enrichment. Thus, by the very people who are entrusted to lead as guardians of the citizens of a country. This grand looting is one of the most important causes of the refugee crises which we see around the world. People fleeing from countries driven by kleptomaniacs and looting their tax money, for example. But also there's been a release of papers around the world. And I refer to just one, the Pandora Papers. And these have revealed how heads of state and senior public officials, and at times senior executives in the private sector, have enriched themselves and placing their loot in shelf companies and jurisdictions outside the country where they have done their looting. The court that will be established on the approval of countries around the world, of which there is a draft statute, as I've said, is intended not only to recover money that has been looted, but also to recover assets that have been stolen and taken to other countries across national borders so that they think they have got it in another jurisdiction and that the arm of the law can't reach them. It's also today, this court, an important governance conversation, because the establishment of such a court will help corruption, which is affecting public markets, external investor confidence, and society's trust in leadership. The United Nations Convention Against Corruption is the only binding universal anti-corruption treaty that exists at present time. It was adopted by the General Assembly of the United Nations in 2003 and came into operation in 2005. 187 member states of the United Nations have ratified the treaty and are mandated to criminalize and combat corruption in their countries. That is the principle. And it's really a principle on which the many people who've contributed to this draft statute of an international anti-corruption court have contributed. But the court will have an ability to investigate this alleged looting and prosecute corrupt leaders, be they in the public or private sector. And we mustn't forget those who help the looters to launder their money: the banks, lawyers, real estate agents, for example, they must not escape what it will be established by the Anti-Corruption Court. The asset division of the draft statute permits financial compensation for the looting of assets. It also provides for in absentia trials, claiming that this is in the interest of justice. Hence, the court is envisaged to be one which has this international character. The court has two divisions, the criminal division and the assets division, which enables it to recover looted assets and to compensate for looting public funds. Several countries have already committed to working towards the establishment of this international anti-corruption court. Countries such as Canada, the UK, Norway, South Africa, I'll mention a few. It's of interest to me as a South African that our new director of the National Prosecuting Authority in South Africa is a strong supporter to establish the IACC. Heads of state, once this court is established, will no longer be able to hide behind state immunity. And the IACC, we must never forget, is an add-on to the national efforts to fight corruption. The issue has become so critical that I'm sure you will agree with me that tempus fugit. We cannot allow time to pass without the IACC becoming a reality. You will certainly agree with us after hearing our learned speakers and the panel discussions which will follow. In the interim, countries have to fight corruption by strengthening institutions, being more transparent in their reporting, and to have real consequence management. This is essential and must be seen to be done. The approval of patronage is actually nothing more than a cover for corruption. It's a favorite mechanism, in fact, for our kleptocrats. Meanwhile, the United Nations International Code of Conduct for public officials should be strictly adopted in regard to conflicts of interest, gifts, and any other abuse of declarations of interest. Public audit of public leaders' lifestyles is a transparent tool which every country in the world should adopt. Whistleblowers have to be protected by a statute which protects their identities, gives them security, and compensates them if their information is bona fide and if from their information the looted money is recovered. I'm confident that this colloquium will result in professionals and corporate leaders in 167 countries around the world to be positive and help in the formation and establishment of the IACC. The spread of the word and this world-class draft of a statute of the establishment of the IACC is a step forward to the reality of the International Anti-Corruption Court. Thank you very much, Karen.
Thank you very much, Prof. King. Absolutely, we are enthralled with what's happening and listening to what you're saying in terms of the establishment. And I think the launch of this is going to be so significant. But let's hear more about what you've said, the International Court. And I'd like to ask Judge Goldstone now to do an introduction in terms of the court. Thank you.
Well, thank you very much, Caroline, and a warm thank you to the Good Governance Academy for having invited us involved in the project to establish an international anti-corruption court to be the topic of this impressive 15th seminar in the series that is being put on by the Good Governance Academy. I'm grateful particularly to Mervyn King for his comprehensive introduction, and I hope I won't repeat too much of what he's already said. Let me begin by talking about corruption in general as a background. As long ago as 2013, the then United Nations High Commissioner for Human Rights, Navi Pillay, said, and I quote her, she said, "Corruption kills. The money stolen through corruption every year is enough to feed the world's hungry 80 times over. Corruption denies them their right to food and, in some cases, their right to life." Navi Pillay said that 13 years ago, and since then the amounts lost to corruption have only continued to rise sharply. The people in those states who are victims of this corruption are deprived of their most basic human rights. So we should recognize that grand corruption or kleptocracy, that is corruption by heads of state or other senior state officials, is very much a human rights issue. But then, as Mervyn King has mentioned, it's also a refugee issue. I would add that in addition, it's a climate issue. It's a major impediment to ameliorating climate change. For example, kleptocrats profit greatly from the illicit forestry trade, which is estimated to be worth in excess of $100 billion annually, and likely much more. The primary recipients of government climate-related development aid include countries that are perceived as being among the most corrupt in the world. Unless something significant is done to deter grand corruption, a large percentage of the billions of dollars in aid intended to diminish climate change will continue to be misappropriated by kleptocrats and their collaborators. The legions of refugees who are overwhelming countries in the Americas and Europe have been fleeing failed states, as Mervyn King has indicated, that are ruled by kleptocrats. They include Syria, Venezuela, and South Sudan. Any effort to alleviate the world's refugee crises must therefore address a fundamental cause of forced migration, grand corruption. The Pandora Papers, to which Mervyn has also referred, published in 2021 by the International Consortium of Investigative Journalists, the ICIJ, provide additional compelling evidence that corrupt leaders throughout the world, aided and abetted by domestic and international accomplices, enrich themselves at the expense of the health and welfare of their often desperate citizens. They secretly use the international banking system to move their substantial ill-gotten gains to foreign countries. The Pandora Papers exposed the secret finances and lavish styles of more than 330 politicians, including 35 then current and former heads of state. I hasten to add that many of them did not relate to ill-gotten funds. Some of them certainly did. The Pandora Papers followed the ICIJ's Panama and Paradise Papers, which provided similar evidence of grand corruption. The global amounts lost annually to corruption for some years has been quite astronomical. Greed appears to have no limits. At a meeting held on the International Anti-Corruption Court last year in Nairobi, the Chief Justice of Kenya, Martha Koome, described corruption as one of Africa's greatest threats. She cited the billions lost annually to grand corruption and illicit financial flows. They are often orchestrated by senior officials who siphon funds into their offshore accounts, shielded by weak domestic enforcement. Chief Justice Koome warned that corruption crosses national boundaries, while national systems, hampered by limited resources, jurisdictional barriers, and political interference, struggle to contain it, conditions that she said continue to fuel impunity. What the Chief Justice said about corruption in Africa is, of course, relevant to many other regions of the world. The point I would like to emphasize today is that, as the Chief Justice emphasized, illicit financial flows cross borders and is very much a transnational phenomenon. The problem needs to be tackled by a transnational mechanism. At present, there is not one. The theft of a country's assets by heads of state, heads of government, and other senior public officials meets with little, if any, opposition from law enforcement authorities, because the kleptocrats and the oligarchs who support them are assured that the police, the prosecutors, and even the courts will turn a blind eye to their plunder. There are unfortunately too many illustrations of this. Russia and some other East European states, Bangladesh under its former government, and in Africa, the billions stolen by the former president of Angola, and in South Africa, the consequences of state capture. There are many other illustrations. At the end of 2024, Isabel dos Santos again hit the headlines. She is the daughter of the late longtime president of Angola, José Eduardo dos Santos. The United Kingdom government statement said that dos Santos had, quote, systematically abused her positions at state-run companies to embezzle at least £350 million, depriving Angola of resources and funding for much-needed development. The then Foreign Secretary David Lammy, now the Deputy Prime Minister of the UK, announced sanctions on dos Santos as part of a crackdown on dirty money and kleptocracy. Previously, the High Court in London had frozen £580 million of her assets in the UK. According to the Luanda leaks, also issued by the International Consortium of International Journalists, Isabel dos Santos' assets frozen in Portugal amounted to more than $550 million. For obvious reasons, and as the dos Santos case illustrates, the assets plundered by senior state officials are never kept at home. Their proceeds are laundered in many foreign jurisdictions, including the United Arab Emirates, the Netherlands, Singapore, Switzerland, the United States, the United Kingdom, and its overseas territories. There are many others. So we see that the problem is pervasive and well publicized. The question we must ask is what steps can be taken in domestic law and in international law to prevent or deter these heinous crimes. The United Nations Convention Against Corruption, UNCTAD, as Mervyn King has indicated, is the only legally binding universal international anti-corruption treaty. It's almost universally adopted by the international community, with 187 member states of the United Nations having ratified it. Most of them have brought into their own laws the provisions they are required to bring by UNCTAD. The Convention contains provisions for international cooperation, technical assistance, and for asset recovery. Most of the members of UNCTAD have promulgated these laws. It is striking that there's no international mechanism to investigate and prosecute the corrupt leaders and those who facilitate their crimes, the banks, the lawyers, the real estate agents, and the other financial providers. What is perhaps more surprising is that there is no international mechanism to freeze, seize, and repatriate the huge illicit financial flows. The International Criminal Court does not have the jurisdiction to investigate or prosecute corrupt leaders. It also lacks the expertise necessary to do so, does not have the investigators, prosecutors, or judges with experience in that field of criminal conduct. The transnational aspects of grand corruption make it extremely difficult for individual governments to tackle the problem on their own. So it is in this context that the establishment of an international anti-corruption court becomes relevant and urgent. Some years ago, I was approached by Judge Mark Wolf, then a senior federal district judge in Boston, to gauge my interest in his idea of establishing an international anti-corruption court. I had then recently been investigating the corruption associated with the United Nations Iraq Oil for Food program. I was a member of the three-person committee chaired by Paul Volcker and established by the then Secretary General of the United Nations, Kofi Annan. The United Nations had lifted an embargo on oil sales by the government of Saddam Hussein on condition that the proceeds of those sales were paid into an escrow account controlled by the UN and which could only be used by Iraq for the purchase of humanitarian goods. Under the scheme, $54 billion worth of oil was sold. Our investigations found that more than 2,000 of the 4,400 companies that did business under the program paid huge bribes to the Saddam Hussein government. They included leading companies in Germany and the UK. Also inculpated were senior officials from France and Canada. There were many, many more. I learned to my amazement that no country was immune from large-scale criminality. So with that experience, I did not need much persuading to join Mark Wolf in 2016 in establishing Integrity Initiatives International, III, as we call it, III, an international civil society organization devoted to fighting corruption. It's in more recent years that III has launched a project to establish the International Anti-Corruption Court, or as we refer to it in shorthand, the IACC, to be set up by international treaty. Until recently, I was the vice chair of III and chaired its treaty drafting committee. I'm delighted that my friend Alan Rock, who will speak to us shortly, has taken my place as chair of the III treaty drafting committee. III recently produced a draft treaty for the IACC. It contains the work of more than 70 experts from around the world. Many of us convened on 3 occasions in Hamburg, Germany, where we were generously hosted by our local foundation, the New Institute Foundation. The draft treaty is currently, I should say, being shared in confidence with a group of over 30 interested governments and some leading civil society organizations. We are seeking their advice and input on the draft treaty, and more particularly with regard to a number of provisions that are novel and might be controversial. Those comments and suggestions will be used by us to update the draft treaty during the rest of this year, which we will then disseminate widely and use for public consultations with governments and civil society organizations. Mervyn King has referred to Susan Lamb, who is, as we call it, the penholder of the draft treaty. She has laboriously and efficiently consolidated and cohered the contributions of all our experts. Susan is an international lawyer and former judge of the Belize Supreme Court and a barrister and solicitor of the High Court of New Zealand. She is also a governmental and UN consultant on counterterrorism and accountability for anti-corruption and atrocity crimes. She recently wrote an excellent policy brief which is available publicly, a policy brief on the draft treaty for the e-publisher, TOAEP, stands for Toak Opsahi Academic E-Publisher, an academic publisher publishing in international law and policy. Describing the elements of the draft treaty, I've drawn on Justice Lamb's work. The draft treaty envisages an international court that will fill the vacuum in the mechanisms designed to prevent, disrupt, and dismantle international corruption, and in particular money laundering. It will do so by complementing domestic efforts to combat corruption. Its jurisdiction would only be exercised when domestic authorities fail to enforce the existing laws they are already obligated to have as members of UNCAC. It would have jurisdiction over crimes of corruption committed by nationals of IACC member states and crimes committed in the territory of an IACC member state. So to those extents, it's similar to the jurisdiction of the International Criminal Court, and like the Rome Statute, provides for complementary jurisdiction. There's a court of last resort. In designing the IACC, we sought to identify lessons from other criminal courts and incorporated features of the Rome Statute for the ICC. We've incorporated those that have achieved widespread acceptance or which have withstood the test of time. We have been careful to omit those features of the ICC that have proved to be less effective. One example is that the IACC will not have any of the pre-trial proceedings that have caused the ICC so much expense and delay. There will be no pre-trial chamber. Other features of the draft treaty are novel and specifically geared to the unique challenges and addressing grand corruption and the illicit financial flows that inevitably follow. The draft treaty incorporates the offences that all UNCAC state parties are required to criminalise in their domestic legislation, such as bribery of a public official and embezzlement of public funds. The treaty also includes others that member states are encouraged by UNCAC to criminalise, the non-mandatory crimes, such as trading in influence, illicit enrichment, and private sector bribery. Our aim is to identify a comprehensive and coherent list of offences that are widely accepted and which will endow the IACC with optimum capacity to address the major harms stemming from grand corruption. The draft treaty contains neither a gravity threshold nor jurisdictional limitation upon those in high-level leadership positions. It recognizes that the seriousness of corruption can be difficult to gauge in dollar terms alone. It also avoids an exclusive focus on those in the most senior official positions, as by doing so the hands of a future prosecutor might be unduly bound and unable in some cases to capture those who are those in fact and in substance most responsible for executing and facilitating grand corruption. Corporations feature prominently in the laundering of stolen assets. In particular, valuable assets, and especially fixed property, are held by shell companies. In this context, a novel feature of the draft treaty is the recognition of legal persons. This would be the first international criminal treaty to recognize legal persons. But those provisions are consistent with evolving norms that have developed in a number of domestic systems. There is presently an optional text that provides for the offence of failure to prevent corruption. We've invited discussion on this potential offence and on many other aspects of the draft treaty. Perhaps the most novel provisions relate to the court having two separate divisions, criminal division and the assets division. Judge Maria Wilson will address the work of the criminal division, and Alan Rock will address the novel assets division. Inspired by the ICC statute, the draft treaty provides that an official's position as a head of state cannot prevent their prosecution before the IACC. The relevance of head of state immunity is predicated on the IACC's existence as an international court. The draft statute seeks to create a multilateral instrument constituting a court of an international character. In the view of the drafters, the IACC would unambiguously have this quality by virtue of its modality of creation and its jurisdiction over offences that are universally proscribed. All crimes within its subject matter jurisdiction are criminalised in all of the vast majority of states, with their criminalisation being either mandated or strongly encouraged by UNCAC. In short, the draft IACC statute combines the collective experience of other international criminal tribunals and novel features addressing the unique challenges of combating grand corruption. At this time, the need to do so on the international level has become increasingly apparent and urgent. While efforts to improve the draft treaty continue, early feedback has been encouraging. It is hoped that the treaty will reflect a high level of consensus and technical proficiency and will facilitate both the treaty adoption process and the court's ultimate success. As Mervyn has also indicated, several countries are committed to working towards the creation of the IACC, including the Netherlands, Canada, Nigeria, Moldova, and Ecuador. Political leaders in the United Kingdom have expressed their support, and especially, as I've mentioned, the Deputy Prime Minister David Lammy. In December of last year, the UK and Norway released new anti-corruption policies that include commitments to be active in dialogues about the IACC. In addition to Nigeria, there are senior officials in other African states that have indicated an interest. They include Zambia, Mozambique, the Democratic Republic of the Congo, Gambia, Rwanda, Senegal, Cote d'Ivoire, and South Africa. There are now over 300 leading figures from across the world, including more than 50 former presidents and prime ministers, and 32 Nobel laureates who have signed a declaration calling for the creation of the International Anti-Corruption Court. Even if kleptocrats are protected at home, within the jurisdiction of a state party or a state willing to accept limited jurisdiction of the court, their stolen assets will be vulnerable. It is crucial, therefore, that states where illicit assets are frequently laundered should ratify the proposed treaty. For this reason, the support from example, the UK is important. It is notorious that valuable fixed property in London worth billions of pounds have been purchased with illicit funds and are held by shell companies. A number of other countries are in a similar position. Singapore and Switzerland come to mind. There are many others. The vulnerability of illicit assets makes the IACC considerably more potent than the International Criminal Court in respect of heads of state who hide behind head of state immunity. Their illicit assets will not enjoy immunity. It would also be an institution able to offer what could be crucial assistance, for example, to states that are willing to investigate and prosecute the corrupt, but do not have the human or financial resources to do so on their own. The IACC's expert investigators, prosecutors, and judges could be called upon for assistance by prosecuting authorities in such countries. It is primarily for this reason that Moldova has endorsed the establishment of the IACC. So the battle against corruption remains, as Mervyn and I have both already indicated, urgent and important. The IACC will work well with domestic anti-corruption initiatives and has the potential of recovering billions of dollars of illicit funds that are hidden in many jurisdictions around the world. Integrity Initiatives International is in the process of establishing subcommittees in major regions of the world, such as Africa, Latin America, and Europe. The African Subcommittee for the IACC is the most advanced and co-chaired by anti-corruption experts from Nigeria and South Africa. The committee includes leaders in the field from Madagascar, Mauritius, Zambia, Botswana, Uganda, Guinea, Kenya, Tanzania, South Africa, Nigeria, Ghana, Sierra Leone, Ivory Coast, Mauritania, Cameroon, and Senegal. It's an impressive list. It is efficiently organized by our Botswana coordinator, Pusetso Morapedi. Its members include directors of a number of national branches of Transparency International. III is concerned that African states should have their voices heard on the future structure and work of the IACC, and that it should participate actively in its planning. This should avoid the unfortunate perception of many African states and the African Union during the early years of the International Criminal Court. The project to establish the court is gaining wider recognition within the international community. I would refer to a few of our most recent engagements. At the end of October last year, I was invited to engage with the G20 Anti-Corruption Working Group. A number of its members expressed interest in the IACC. Also during October of last year, members of the UK House of Lords raised a proposal for the IACC during a debate on international corruption and illicit financing. In December of 2025, governments and civil society convened in Doha, Qatar, for the 11th Conference of States Parties to UNCAC. The meetings were attended by III board members, Alan Rock from Canada, and Serena Ibrahim, the founder of Youth Against Corruption from Lebanon. They participated in a side event on the IACC and were joined by South Africa's newly appointed National Director of Public Prosecutions, who again Mervyn King has mentioned, Andy Matibi, a strong supporter of the IACC. Others who joined them was Ola Kayode, the chair of Nigeria's Economic Financial Crimes Commission, and Ambassador Caroline Veyers, the Dutch Special Envoy for Anti-Corruption. They all highlighted the persistent obstacles to cross-border asset recovery, the role of professional enablers, and the importance of international cooperation. The panel was moderated by Katakandriana Rafatoson, the Vice Chair of Transparency International and Executive Director of the Resource Justice Network. The South African Minister of Justice was in the audience in Qatar and expressed interest in the IACC. Since then, together with South African colleagues, we have had a constructive discussion with the Minister of Justice, a meeting and her senior officials. Further consultations are being arranged with them. It is my hope that South Africa might take a leading role in organizing a meeting of African governments to discuss the establishment of the IACC and to discuss the draft treaty. We obviously hope that similar meetings will be held in other regions of the world. In November 2025, III Vice Chair Dr. Charles Adeogun Phillips of Nigeria spoke at the 14th Global Investigative Journalism Conference in Kuala Lumpur, the world's largest gathering of investigative reporters from more than 135 countries. Dr. Adeogun Phillips shared his experience as a former lead prosecutor on international crimes and explained why he and others at III are advocating for an IACC. He highlighted structural limitations in current systems that allow kleptocrats to avoid justice, and he spoke directly about the need for effective asset recovery that returns stolen wealth to the countries and communities harmed by corruption. In November of last year, III Executive Director Ian Lynch was a special guest at the World Liberty Congress gathering in Berlin. The WLC is the world's largest action-oriented movement of political activists standing up to autocracy and seeking democratic transitions in their own countries. As vital voices representing the populations most severely impacted by corruption, they are a key constituency that III engages with on the IACC project. Let me lastly mention that also in November of last year, III, Integrity Initiatives International, launched the Coalition for the International Anti-Corruption Court. This coalition brings together civil society organizations and individuals from across regions to strengthen coordination of advocacy for the establishment of the IACC. The coalition, launched in November, convened 175 participants from 48 countries, including representatives of regional and global civil society organizations, national anti-corruption groups, and leading practitioners. Other organizations are encouraged to join this coalition. And really, finally, a bill to improve Canada's Magnitsky Law includes endorsement of the IACC in its preamble. The bill has very recently passed a second reading in the House of Commons in Ottawa. So there can be no doubt that the IACC would complement domestic efforts to combat corruption, and especially grand corruption. It would assist in restricting illicit financial flows and facilitate the repatriation at an appropriate time of those funds to their true owners, the people from whom they have been stolen. In this context, I would again emphasize that the IACC will not bring an end to grand corruption, but I have no doubt that it will act as a serious deterrent and also facilitate the return of many laundered assets to their rightful owners. I would emphasize too that the IACC will not in any way contradict or hamper any of the efforts of domestic anti-corruption activities, but it would rather augment their work. The one will complement the other. So we are calling on governments and civil society to join the project to establish the IACC. It is now time for this court to be established. I thank you for your attention and look forward to questions and discussion on the International Anti-Corruption Court. Thank you very much.
Thank you so much, Judge Goldstone. What an impressive and important piece of work. Well done to everybody involved. This is just needed, important, and as you say, there's just a huge gap currently around this matter, and it's in everybody's interest, business, civil society, and individuals that we do establish this effectively and appropriately, and as you say, in a complementary way to what's existing. So thank you very much. And I'd like to hand over now to Judge Wilson, and Judge Wilson is going to talk to us about the criminal side of things and enforcement. So Judge Wilson, thank you so much.
Thank you. Good morning to you all. Greetings from Trinidad and Tobago. I wish to thank the Good Governance Academy for giving me the opportunity to share with you our vision for the International Anti-Corruption Court, which I will refer to as the IAC Court. We owe a lot to Justice Mark Wolf and Justice Richard Goldstone, who have contributed significantly to the idea of this court, and they continue to contribute in major ways to its creation. Additionally, I would also like to thank the many international experts, including Alan Rock, who have contributed their ideas, expertise, and their time to build on the initial concept, and they continue to do so. It is a pleasure to be working with them all to make this court a reality. The work continues on the fine-tuning of the statute for this court. It is a work in progress. I look forward to any questions and/or comments which you might have on the proposed IAC court. This will assist us in getting it right. For some questions, we might not have the answers at this time, but it will make us reflect on how we could address any issues which you might raise. We would like the court to achieve its main purpose, that is to hold heads of states and public officials and their enablers accountable for the commission of corrupt offenses. The enablers include lawyers, accountants, real estate agents, and service providers. We also see the IAC court as acting as a deterrence to the commission of crimes under its jurisdiction by establishing a credible threat of investigation and prosecution. My presentation today is on the role of the Criminal Division of the International Anti-Corruption Court. Our vision is to have an international court with two chambers, a criminal and an asset chamber at the first instance, and an appeal court from which all appeals can go to from these first instance courts. Why international? I will paraphrase the response of the Chief Justice of Kenya to this question. Corruption crosses national borders, while national systems, hampered by limited resources, jurisdictional barriers, and political interference, struggle to contain it. It is very much a transnational phenomenon with a problem, and the problem needs to be tackled by a transnational mechanism. At present, there is not one. There is no other court in existence like the IAC court. There are national courts which have jurisdiction over corruption offenses, and there are international courts which have jurisdiction over matters not involving corruption types of offenses. For example, there's the International Court of Justice, as we all know, the principal judicial organ of the UN, which addresses legal disputes submitted by its member states of the UN between states in accordance with international law. And it also gives advisory opinions on legal questions referred to it by other organs of the UN. Only states can be party to a contentious case before the ICJ. There's also the International Criminal Court, a permanent international court, the ICTY, the ICTR, these other courts. They do not deal with corruption offenses. They prosecute individuals for international crimes such as genocide, war crimes, and crimes against humanity. And in the case of the ICC, crimes of aggression. There's also the Special Tribunal of Lebanon. This is a court which has an international component and a national component, and was established by the UN General Assembly at the request of the relevant UN member state with states' participation. So none of these international tribunals have jurisdiction over corruption courts. So the IAC court will be unique. We support this court because it addresses an enforcement gap in the international ecosystem, a gap which we believe the ICC court would fill. So this is what we envisage. The criminal division of the IAC court will have jurisdiction over core crimes derived from the United Nations Convention Against Corruption, as you heard mentioned by Justice Goldstone. Our rationale for selection of these crimes is because the UNCAC was established since 2003 and is the only legally binding international anti-corruption multilateral treaty, with 192 members being part of this convention as of September 2025. This represents almost all the members of the United Nations, which numbers 193. The core crimes of the IAC court will include offenses that are both mandatory and also non-mandatory for state parties to UNCAC to criminalize as well as to criminalize. These offenses are as follows: bribery of national public officials, bribery of foreign public officials and officials of international organizations, embezzlement, misappropriation, and other diversion of property by a public official, laundering of proceeds of crime, trading in influence, abuse of functions, illicit enrichment, concealment, offenses against the administration of justice, and we're considering offenses committed by private entities. For this court was also based on the principle of complementarity. In relation to the criminal jurisdiction, this means that this will be a court of last resort. That is, only if national courts are unwilling and unable to investigate and prosecute corruption offenses that the IAC court will investigate and prosecute such criminal offenses. We have adopted this concept, referred to as the principle of complementarity. We have taken this from the Rome Statute because we believe it is a primary responsibility of nations to investigate and prosecute such offenses. The IAC court will complement national jurisdictions rather than assume their primary role to investigate and prosecute such offenses. This preserves the sovereignty of nations, but also recognizes the international nature of corruption. That is, that the ill-gotten gains are often placed in overseas banks or invested in properties abroad and shell companies outside the country, and that corruption can ultimately impact on international peace and security. Who then will be the parties before this court? The Criminal Division Court shall have jurisdiction over only natural and legal persons. We have to do a lot more work on the jurisdictions over legal person, but we felt that this is an important aspect of the court. Now, the exercise of the jurisdiction of the court will be, in its criminal jurisdiction, will be in a situation where there's evidence or allegations of one or more crimes within the jurisdiction of the court, and they are referred to the prosecutor by a state party. So that's one of the ways the prosecutor can have material to work with. Another is the prosecutor can decide of his own initiative to prosecute. He shall initiate investigations proprio motu, that on the basis of information obtained from any source, including from governments, United Nations organs, intergovernmental and non-governmental organizations. The prosecutor may assess the information received or obtained and decide whether it is sufficient basis to proceed in light of the overall objectives of this statute. Once that is determined, that there is a reasonable basis to conclude that a crime under the statute has been committed, the prosecutor shall prepare an indictment containing a concise statement of the facts and the crimes with which the accused is charged under the statute. The indictment will then be transmitted to a judge of the criminal division, and I will continue with that a bit later on. There's also the requirement to satisfy the court's temporal jurisdiction. The criminal division of the court has jurisdiction only with respect to crimes committed after the entry into force of this statute. And if at the time and in the place of its commission, the conduct was an offense under the law of a state that had jurisdiction over the offense. Moving on now to territorial jurisdiction. The court may exercise its jurisdiction in one or more of the following states which are parties to the statute or have accepted the jurisdiction of the court. The state on which the territory of which the conduct constituting an offense occurred in whole or in part, or the state where any proceeds or property derived from the offense are located. Additionally, if the conduct constituting an offense was committed in whole or in part on board a vessel, vehicle, or aircraft, the state of registration or flag of that vessel, vehicle, or aircraft. Moving on to national and residence jurisdiction, the court may exercise its jurisdiction if one or more of the following states are parties to this statute or have accepted the jurisdiction of the court. So the state of which the person accused of an offense is a national or has habitual residence in that state, or the person accused of the offense, being a non-national, is an employee. In relation to legal persons, the state in which any legal person subject to the provisions of the statute is registered or conducts business. So moving on, the whole purpose of the court is to be able to give back to the victims of corruption. So a crucial feature of the court will be its authority to freeze and seize assets. So far, we think that both divisions will have the authority to seize and freeze laundered, stolen assets. More of that will, my colleague will discuss more how the asset division will deal with that. Another essential feature of the court is the participation of victims in the proceedings. We have adopted that from the International Criminal Court. We feel it's essential for victims to have their voices heard. In this court, unlike other courts, there will be irrelevance of official capacity. So the statute of the court will apply to all persons without any distinction based on a person's official capacity. For example, heads of states or heads of governments, they will not be treated specially. They will not obtain immunity under our statute. Another thing to note is that the court will not have jurisdiction over national persons who are under the age of 18 at the time of the commission of the offense. Now, the interesting thing about the whole concept of complementarity, the court will also use its experts, whether expert investigators, prosecutors, and judges, to assist in building capacity in states who are willing but are unable to, in fact, prosecute. So that's the other side of the complementarity issue. We want the states to initially take the position of investigating and prosecuting. And any assistance which we can provide in that regard, we will do so with all the expertise that we will have at hand. Now, moving on to continuing from what I started before, what will actually happen? How would this happen? So we have identified all the different aspects of the jurisdiction. How would it unfold? Well, it will unfold in this way. The prosecutor, after investigating the matter, will prepare an indictment, which is a concise statement of the nature of the offense and for which the person is being charged. And that indictment will be transmitted to a trial judge of the criminal division. And that judge will have to be satisfied that there's a prima facie case. If he confirms that there is, then the matter proceeds. And if he finds that there is no prima facie case, it will be dismissed. So that is the process. And thereafter, upon confirmation of the indictment, the judge, at the request of the prosecutor, will issue orders and warrants for the arrest, detention, and surrender of the accused person and the transfer of that person. Now, this is where international cooperation will matter. The organization, the court will rely on state parties to take steps to arrest such persons accused of crimes under its court. That is not an easy scenario because we do require cooperation. So whilst at the ICC, I worked on the case concerning the former president of Sudan. And after preparing a warrant, we have still not been able to execute that warrant. It all depends on cooperation of the state parties. So this is something we really need to foster and work on. So once a person is arrested, that person has to be brought before a competent court having jurisdiction promptly. And at that stage, the person can apply for interim release. Of course, the chamber court must always be notified. Thereafter, the issue of disclosure of documents will be dealt with. The court will pay attention to the protection of victims and witnesses, because in order for persons to feel free to testify in such courts, they must be guaranteed such protection. So you heard Justice Goldstone speak about whistleblowers. They in particular require protection of the court to ensure they'll continue to come forward. And then, of course, it gets to the trial stage. At the trial stage, the burden of proof is the same as in all criminal matters, beyond all reasonable doubt. There's a presumption of innocence, and then the prosecutor will have to prove beyond reasonable doubt that such a person is guilty. And so the trial process will take place. Later on, again, the court will rely on state parties to assist, if the person is found guilty, in providing a place for them to be imprisoned. So that is a process that will take place once the indictment has been confirmed. The court The seat of the court has not yet been determined, but I'm sure in due course it will be. And as alluded to by Justice Goldstone, the idea of this court is to be efficient. There'll be no pretrial chambers. The judge assigned will attend to all those interlocutory matters. There'll be no permanently hired judges. Judges will be only hired to work on active matters. And in that way, we hoped to have an efficient and effective court and to use any fines obtained from proceedings to defray the cost of operations. So this is some of the key issues in relation to this court, which I wanted to share with you. So I thank you very much for allowing me to share my vision, our vision of this court. Thank you.
Thank you so much, Judge Wilson, and thank you for waking up so early, all the way from Trinidad and Tobago. We really thank you for your insights, for your words of wisdom, and for explaining the process to us. I think you explained it in such a way that everyone online could understand what the process was and didn't need to be lawyers or skilled in this area. So I think it's very clear. And it's so clear that we actually got people bringing up skepticism and finding issues. So we've got lots of questions in the Q&A that will come later on after our break when we do our business roundtable, and we have our attendee questions when we'll be asking those. So thank you so much, Judge Wilson. And I'm going to move now to Prof. Rock. And Prof. Rock has been mentioned both by Judge Goldstone and Judge Wilson. So the spotlight's on you, Alan. Thank you so much.
Thank you, Carolyn. And may I say, on behalf of all of us at III, how grateful we are to the Good Governance Academy and Dr. Mervyn King and the outstanding team. This is the 15th Colloquium. And over the many years, the quality programming of Good Governance Academy has brought news and information, education to tens of thousands of people in so many countries around the world. It's a remarkable achievement. I don't know of any other facility, really, that allows access to that many participants at a single time in such a coherent and organized way. So thank you very much, Dr. King and team, for allowing us to use this instrument to communicate our message to so many people today. Grand corruption, of course, is an evil that poisons so much of governance globally. It's responsible for so much harm around the world. And one can only imagine how much better the world would be if all of the dollars intended to improve social services, education, healthcare, housing, infrastructure, actually used for the intended purpose. Can you imagine? Well, instead, we're left with the world we have. And I should explain how I got involved in this international anti-corruption court cause, because it relates to what I was just saying. For many years, I've worked with the World Refugee and Migration Council, looking at the ways in which the world can respond in a more effective and humane way to forced displacement, to the 25 million refugees, the 100 million internally displaced people around the world. And after years of working in that sector, I came to the conclusion that one of the root causes of forced displacement, and Dr. King made this point in his opening statement, one of the root causes of forced displacement, of internal displacement and refugees who cross borders, is grand corruption. Because the kleptocrats have so weakened governance in the state by stealing money, by infecting all of its instruments with their corruption, that it no longer is capable of responding to the needs of the population. Either violence or instability results, and they cross a border and leave. So grand corruption is the root of so much that afflicts today's world. It must be attacked frontally and effectively. My task today is to speak about the second chamber in the International Anti-Corruption Court, the assets chamber, not criminal prosecution, but asset recovery. And I should mention that I've prepared a paper of 8 or 9 pages, which has been made available to you, I think, on the website. So I won't repeat what's in the paper, but let me just summarize and speak broadly to the whole concept of an asset division in the new proposed court. And I start with the proposition that there are really 2 dimensions in responding to grand corruption. The first, of course, is the dimension that Justice Wilson just spoke about, which is criminal accountability, which is prosecuting kleptocrats and their enablers, ending impunity, enforcing existing laws, achieving deterrence, as Justice Wilson said, establishing a credible threat of being prosecuted so people think twice before engaging in grand corruption. And the criminal division of the International Anti-Corruption Court will meet that need. That is its function. But there's a second dimension to grand corruption, and it's of surpassing importance to those states and their populations who've been victimized by grand corruption. And that dimension involves the returning of the looted assets to the rightful owners, where the kleptocrats have stolen from their own treasury, and is so often the case, taken the money or the assets and put them offshore in another country. That means repatriating them, sending them back so they can be used for the purposes for which they were intended, which is to meet the needs of the population. Now, could an international anti-corruption court with just a criminal chamber do all of that? Well, we concluded that that would be impractical, unrealistic. There are only so many prosecutors, only so many courtrooms, only so many criminal proceedings that can be instituted. And if you look at the hundreds of billions of dollars that are stolen regularly around the world, it's just not practical to think that through criminal prosecution alone, we can meet the need for repatriating the assets to the country of origin. Of course, if and when there's a criminal prosecution, and it becomes clear that there are monies available that have been frozen, that are the proceeds of crime, then as part of the criminal process, the IACC will engage the asset division in assisting to find out who's the rightful owner and send it back. So incidental to the criminal proceeding, there can be repatriation. And indeed, if the prosecutor investigates but decides not actually to institute a prosecution, not to prepare the indictment because the evidence isn't sufficient, but there is property that's identifiable and can be traced to illicit conduct, there can be what's the equivalent of civil forfeiture, a non-conviction based forfeiture by which the money can be taken and returned to those to whom it rightfully belongs. So the criminal dimension is capable of responding in part to the need for repatriation, but the vast amounts out there that are stolen every year and placed offshore, the criminal function of the IACC is simply not capable of responding to that scale of need for repatriation. And that's why those who've designed the International Anti-Corruption Court and drafted the treaty have included a feature with a second chamber, a second division, which is responsible, among other things, for repatriation. So perhaps the most important function of the assets division will be to serve as a court that will receive, consider, and decide upon claims made by a victim state for the return of its stolen assets that are located in another state. And by providing an independent and impartial tribunal for the fair and expeditious resolution of such disputes, in a chamber that's accessible to all states, where the standard of proof is civil, not criminal, where the accent is on simplicity of process, where the court's mandate is to do what is just in all the circumstances of the case, the Assets Division of the International Anti-Corruption Court will fill a gap in the international system and in global governance. That gap results at present in asset recovery being an uncertain, unpredictable, and often unfair endeavor. Those who look at the present system for asset recovery will conclude quickly that, first of all, there is no single international tribunal or court that's empowered to make binding and authoritative decisions about the ownership of looted assets and the prospect of their return. Now, the UN Convention Against Corruption, which was such a giant step forward when it was adopted in 2003, and which now, as Justice Goldstone points out, it has been signed and ratified by almost every member state of the United Nations, UNCAC, as it's called, provides extensively for cooperation among states in all matters affecting corruption, including the return of assets. And in fact, Part 5 of UNCAC is devoted specifically to that subject. But while it calls for states to exercise cooperation in good faith and to work together and to allow litigation in their own states, and while it provides for negotiation between the victim state and the holding state for the return of assets, there's no mechanism by which the complaining or victim state can get an authoritative judgment on its entitlement to the return of the money. And that has led to so much frustration on the part of victim states who are navigating a maze of informal, unpredictable ways and means by which these negotiations occur. I know, speaking from Canada, we have a section in our Global Affairs Ministry of lawyers who are specifically tasked with the responsibility of negotiating return using mutual legal assistance. But it's invariably complicated. Accessing evidence is difficult, and the outcome is often unpredictable. The UNCAC provides in Article 66 that if negotiation doesn't work in such cases, resort to arbitration and eventually go to the International Court of Justice, but that's only on the question of the interpretation and application of the treaty. It is not a method by which contested issues of entitlement to the return of assets can be authoritatively decided. Sometimes, at present, the victim state will commence litigation in the state in which the assets reside, and that's encouraged by UNCAC. And as we know, there are often regional efforts or agreements or protocols that are intended to assist in the return and recovery of assets. One thinks in the case of South Africa of Arinsa. One thinks of Karen or Arin in other regions of the world. One can look at the arrangements among the members of the G20 group of countries who have their own protocol, at the Addis Ababa Action Plan, at the Lausanne Guidelines. One can look as well as the many valuable sources of technical support and advice, whether it's the World Bank's STAR initiative that gives technical assistance, or the wonderful International Center on Asset Recovery in Basel, the Basel Institute of Governance, all of which are supported internationally by a web of cooperative mechanisms like the Financial Action Task Force. And of course, there are financial intelligence units around the world to share information as well. And that's all very impressive. But it's a patchwork. It's a patchwork of improvised and incomplete efforts to facilitate the recovery of assets. As worthy as those initiatives are, they don't respond ultimately to the need to have a place you can take a dispute about the return of assets for an impartial, independent adjudication on the facts by an authoritative and binding tribunal. A single, empowered forum to which states can turn for the binding adjudication of issues, that's what is needed, and that is what the Assets Division of the International Anti-Corruption Court is intended to provide. So how would it work? First of all, this capacity to resolve disputes about recovery of assets would be open to any state, not just a state party to the treaty, but any state that was prepared on an ad hoc basis to subject itself to the jurisdiction of the court for that purpose. So that would make it accessible to all. Second, it's accessible even when there's no criminal prosecution. So if a victim state knows that money was stolen and put on deposit in Canada, for example, and there was a dispute about its return, then whether or not there's a criminal prosecution in the International Anti-Corruption Court or elsewhere, the court's jurisdiction to resolve issues of recovery can be engaged. In deciding matters put before it, the Assets Division will adjudicate based on the lower standard of proof, that is to say, the balance of probabilities, as opposed to the criminal standard of proof beyond a reasonable doubt. And the Assets Division will be tasked with assessing the legal and factual basis of a request for forfeiture and return, including potential requests by interveners or third parties who might have a claim on the assets. And the court would make a binding determination in respect of those competing claims. The court would be able to order the transfer of financial assets, the liquidation of physical assets, and that funds be held in escrow pending resolution of a request for restitution or return. The court can make orders of confiscation and forfeiture if a requested or requesting state lacks the capacity or willingness to do so. The court would be able to receive submissions on the proposed disposal of assets and identifying trustworthy and equitable channels for their return to make sure they weren't stolen again or put at peril. And the court can resolve disputes between and among parties concerning the recovery of assets and make orders on an equitable and lawful distribution of assets that are binding on all parties. So in summary, what is proposed in the treaty that's now being considered by more than 30 governments around the world is an international tribunal which will have the capacity to respond to both dimensions of grand corruption. Yes, accountability, deterrence, the end of impunity, prosecuting those responsible and their enablers, but at the same time, separately, the capacity to resolve disputes between states about whether to return the money and to whom. And in our view, both of these functions are crucial as the world grapples with the evil of grand corruption. And we very much hope that over the course of the next few years, we will be able to, working with governments around the world, put in place these mechanisms for the benefit of all concerned, particularly the vulnerable populations who are deprived of the benefit of looted assets that were intended to serve them. So I leave it there, Carol, and I pass it back to you, and I thank you again for this wonderful opportunity.
Thank you, Alan. What an amazing speech. The content was rich, and I think it really just summarizes up for us exactly the why and the what of the International Anti-Corruption Court. And I think that really leaves us with a great point where we can break for a body break, a cup of tea, to take a break before we go into the how, and how businesses will engage with something like this, how businesses are dealing with something like this, and with corruption and anti-corruption measures. There's a lot on the chat asking about whistleblowing. Lots and lots of questions coming into the Q&A. So we're going to take a 5-minute break. So we're going to start just before the bottom of the hour. Internationally, except if you're in India, maybe it's the top of the hour for you. So we're going to take 5 minutes and start again just before the bottom of the hour. I'm not going to start exactly at the bottom of the hour because we do need these minutes. So please, everyone, join us again. Take a good break. Refresh yourselves. We're going to go into what does this actually mean for you now? We've heard why it's completely necessary, how it operates, and the fact that we have the criminal side, and as Prof. Rock told us, all about the assets recovery and why that's so important for us. So we go into the second half of our colloquium on how. Please join us just before the bottom of the hour. Thanks, everyone.
And only for 1 minute and
Yeah.
Leave this open for a minute, get some fresh air in there, you know. And close your cupboard, look, it's open. You want a glass of water? Can I bring you water? Would you take your pills at 12?
Yeah.
You want water?
Yeah.
Oh, good. I'm going to open this window a tiny bit. It's very foggy in here. You'll be falling asleep. I think we're all back. Prof King, just going to mute you. There we go. And just waiting for everybody to come back online. Great. Thanks, everyone. Prof King, I just had to mute you. Sorry about that. Let me just ask you to unmute. There we go. So that at least when you want to speak, we can hear you. Thanks, everyone, for taking a break. You can't hear me. Can you hear me now, Sebastian? Oh, everybody can hear me. Great. Thanks. Welcome back. I'd now have the great pleasure of asking our chair, Alan Johnson, previous president of the International Federation of Accountants, to host a business roundtable with some very special guests with us today. So I'm going to hand over to you, Alan, now. Thank you.
Thank you, Caroline. Good afternoon, good morning, and good evening, everyone, and thank you for joining us. We now have 722 participants, so it's great to have you with us. Let me start by thanking Professor Mervyn King, Justices Maria Wilson and Richard Goldstone, and Professor Alan Rock for their keynote remarks, introducing us to the work being done to establish a new international anti-corruption court to investigate cases of international corruption, illicit enrichment, and the laundering of stolen assets. As they have said, it is proposed that the IACC will have both a criminal and an assets division. I'm sure you will all agree that corruption is a major global problem, both economically and socially. It affects everyday life in most countries. For example, it affects healthcare or the lack of investment in healthcare, education, infrastructure, and often leads to political and democratic instability, organized crime, and reduced foreign investment, amongst many others. So whilst many countries do have anti-bribery corruption laws, the main issue is that enforcement is uneven and prosecutions remain very rare. So we've put together today a panel of experts so we can discuss what can and needs to be done to address international corruption and how the IACC can play a global role in helping to eliminate international corruption and helping to ensure that stolen assets are returned to where they belong, i.e. to the citizens. So let me introduce our panelists. Desi Gotsakova is a lawyer and senior anti-corruption expert and brings over 27 years of experience on integrity, rule of law, and governance. She specializes in international and institutional integrity frameworks, asset tracing, and confiscation, and supports the practical implementation of anti-corruption standards. Desi has served as a director of the Regional Anti-Corruption Initiative, covering 9 member states, including Bulgaria, Romania, Albania, Serbia, and Bosnia-Herzegovina, leading international cooperation to support anti-corruption efforts. Lorraine Ocampos is a former senior economist at the IMF and research director at the Central Bank of Paraguay. She has more than 25 years of international experience in fiscal policy, public financial management, and economic reform across both Latin America, the Caribbean, Africa, and the Middle East. And finally, Dr. Ruel Koza. He's a leading voice in South Africa, a prominent businessman, and leads on leadership, governance, and ethics, and has spoken out publicly about corruption and state capture, particularly in South Africa. He has more than 40 years in executive management and is currently the chairman of Zana Investments and Discovery Bank and a board member of Jubilee Metals Group. His past roles include chair of Nedbank, one of the largest banks in Africa, Eskom Holdings, and GlaxoSmithKline South Africa. He is also president of the South African Institute of Directors, and he has worked closely with Professor Mervyn King to develop what South Africa knows as the corporate governance codes, the King codes, known as King 1, King 2, King 3, King 4, and King 5. So I thank Desi, Lorraine, and Roel for agreeing to be on today's panel and look forward to some interesting discussions. So let's start the discussion. So let me start with you, Desi. Without obviously giving any specific examples, because obviously we want to protect the integrity of governments individuals. But how would you assess the level of corruption in your country and in your region? And have you seen any specific and significant improvement in the level of such illicit activities?
Many thanks, Alan, for the very kind words and introduction. And I would like also to thank the Good Governance Academy for the invitation and being able to speak about the experience of the Southeastern Europe. Hi from Sofia, Bulgaria, to everyone present. Going back to your question, the picture in Southeastern Europe is complex and increasingly politically sensitive with regards to anti-corruption. I have to admit that the region has made important progress over the years in forms of anti-corruption legislation, institutional building, and regional cooperation. However, as in many other parts of the world, implementation and enforcement remain major challenges, and in particular, in relation to grand corruption and politically sensitive cases. This is the reason why in several countries from the region, civil society and independent observers increasingly speak not only about corruption, but about elements of state capture and entrenched kleptocratic networks. Public frustration is also becoming more visible. We have seen sustained anti-corruption and anti-government protests, as well as periodic waves of public protest across the region. In Bulgaria, in Serbia, Albania, North Macedonia, some of those protests even resulted to government collapse. For example, in Bulgaria, we have had it just last winter. However, despite the enormous public attention, media exposure, and political consequences of corruption cases, they, especially when it comes to grand corruption, they have relatively limited final accountability. This contributes to a growing distrust in institutions and in our region. So the problem in the region is therefore not only corruption itself, but the systematic impunity, concentration of power, and weak institutional resilience, as well as the corrupted politicians moving assets across jurisdictions, which makes it difficult to trace and recover. So I would say that in this sense, our region faces the same challenges as many other parts of the world when it comes to tracing assets, cross-border cooperation, and securing effective accountability. This is why it is very important that we participate in the discussions around the International Anti-Corruption Court jurisdiction, and I really hope that our countries from the region would join the initiative and be part of it.
Thank you. I should have said, by the way, in my introduction, congratulations to Bulgaria for winning the Eurovision Song Contest on Saturday.
Thank you very much.
What a
Thank
great
you very
achievement for your country and your citizens. And I am sure there was absolutely no corruption involved in that whatsoever. Ruel, can I, and I mean that, there wasn't. Ruel, can I just turn to you with the same question, please?
No, thanks a lot, Alan. Thanks for the very kind words of introduction. Just a little correction. My chairmanship of ESCOM and NetBank are historic. I'm currently chairman of Discovery Bank.
Okay, thank you.
Corporate level. Yeah, I think there are, perhaps I could just flag a few instances of corruption and what is being done to actually address that. First, I want to submit that corruption is not merely theft. It is more than that. It is collusion. It is silence where there should be outrage. It is the betrayal of trust by leaders, states, by institutions, and by corporations. So it is pretty pervasive. I don't want to dwell much on examples, but let me just flag one or two of the examples that have been manifesting, plaguing us as manifestations of corruption. Let me mention the Gupta state capture, because I think that was corruption on a grand scale. A private family in cahoots with senior politicians manipulated ministerial appointments, secured contracts, and bent the machinery of state to their will. And the lesson we learned from such corruption is that state capture is not theft alone. It is the hollowing out of democracy itself. And the important thing about this particular example is that the IACC that we're planning to establish would actually help a great deal, because following doing all of that, the perpetrators of this corruption actually left the country. And they cannot be, it's difficult to repatriate them back to South Africa. Now, a body such as we have in mind that has been so amply outlined by both Mervyn and Judge Goldstein would actually go a long way in helping our country to actually deal with something of that magnitude. Now, what do we do and to actually address corruption at such large scale, both in South Africa and in other parts of Africa? There are a number of Africa-specific institutions and frameworks that seek to address this, that I think would make common cause with IACC. There's the African Union Advisory Board on Corruption, which was established under the AU Convention in 2003. It promotes mechanisms to prevent and eradicate corruption. And 44 out of 45 AU states have signed the convention. I would suggest that in terms of linking up with the IACC, this would be a good point of entry. We also have the African Peer Review Mechanism, which enables states to assess each other's governance standards, including dealing with corruption. And then 43 countries have voluntarily joined. Third is the national anti-corruption agencies, where countries like Botswana and Seychelles demonstrate strong governance through effective ACAs, while others struggle with weak enforcement. And enforcement is actually one huge challenge. There are those who have the will to do something about tackling corruption, but enforcement or implementation does tend to be a big problem. And finally, Africa Anti-Corruption Hub, based in Nairobi. It coordinates regional platforms, Eastern, Southern, Western, to align anti-corruption strategies with Agenda 2063 and the SDGs. So perhaps I could stop there and wait for specific questions further down the line.
Thank you. Very good morning to you, Lorraine. Same set of questions to you, please. You're on mute. Yeah.
Thank you. Thank you,
Thank you.
Alan, and to everybody here participating in this panel, and also to the participants of all over the world, which is fantastic, because this is really a very important subject, and so important as the other presentation said, is human rights, is climate change, is not only a thing that people are losing. The majority of the population is losing with corruption, but is really affecting all aspects of the society. In Latin America in particular, and in Paraguay, the levels of corruption are among the highest in the world, and everybody knows that, with some exceptions like Uruguay and Chile are the less corrupt countries in the region, and very close to the level of the less corrupt region in the world, which is Western Europe, which has 9 of the 10 less corrupt countries in the world. Then if we see the Corruption Perception Index of Transparency International, the last data, the Americas score an average of 42, 200. 42 is 0 is very corrupt countries or regions, and 100 is no corruption. Nobody has 100. We have to say that. The average in Western Europe, I think, is 62, something like that, and with countries which are which are close to 100, like Denmark and the Nordic countries, and others lower, like Italy, which is well known, which are lower than even in Uruguay, in Latin America. But what we have seen, according to this corruption perception index, which is a perception, is a subjective index. It's not like others, like a more objective, like the Global Corruption Index, that shows how effective are institutions to impede acts of corruption. But they show similar results. But we have seen all over the world is that, like since 2012, all the index have declined. Then there is an issue over the world with corruption. And even the countries that have the best levels, they have somewhat declined. In the Americas, years of inactions by governments in addressing corruption has weakened democracy and has allowed the growth of organized crime, which we call here the narco states, which have been infiltrated in politics. And of course, there is a direct relation with corruption. And the serious impacts are on human rights, at some of the speakers had mentioned, and security. And the high levels of corruption fuels criminality, weaken public institutions, and create parallel states. And we have seen countries like, for example, Ecuador, that was quite well managed 10 years ago, now is really a very high criminality, and like the narcos organization have taken the state in parallel institutions, which is really very damaging for everything. In the 2025, if I continue to take the Corruption Perception Index of Transparency International, what shows is that corruption remains a serious threat in every part of the world. Although there are, of course, limited signs of progress. While 31 countries have significantly reduced their corruption levels since 2012, the rest are failing to tackle the problem. They have stayed stagnant or got worse during the same period. And I have seen that in countries like in Paraguay, where I'm living right now, more than 2/3 of countries score below 50 in the index. Below 50 is they are closing to zero. People are paying the price, as Professor King mentioned, as corruption leads to underfunded hospitals, bad quality of education, poor and insufficient infrastructure such as roads and bridges, and the people are suffering. Several actions have been taken over the last years, pushed in part by civil society pressure. For example, the majority of countries have signed international and regional conventions against corruption. Anti-corruption secretariats have been created. And some of them, we are seeing now that they have been closed, like in Paraguay. They are like restructured, they say, but we really don't know very well what they are doing. In countries such as Brazil and Colombia, we have seen progress in environmental measures that intercept with corruption. For example, they have been adopting to impede the damaging advance of deforestation, illegal mining, traffic of endangered species. In Colombia, if you knowingly, there is a good example. There are problems, of course, with the implementation, but at least they are doing something very interesting, I will say. I could set an example for other countries. If you knowingly sell property to a drug trafficker or a person whose income came from that type of activities, the Colombian government can seize the property without compensation. And I know people that have that problem. Then they have to do a very good due diligence before selling people to a person that has ill-gotten incomes, at least to know very well, which is a good example of this. Nonetheless, the biggest challenge is to maintain and increase these efforts that they have been done, which depend on strong and consistent political will, and sometimes that fails. They change parties, they change presidents that are not so much willing to tackle corruption, and things fail. The institutional independence is very, very important. And now we are seeing in many countries that there are so much interference from the executive power to other powers in the state, which is very damaging. The strengthening the legal framework is so important, and determine enforcement, which also Desislava had mentioned. Then you can have a good strengthened legal framework, but there is not well implemented, or there is too much impunity. And the capacity building and ability of the civil society also to push for enforcement across criminal and financial fronts, which are very important. Then there have been some progress, but they are very vulnerable to changes in politics and then to interference of other forces like the drug dealers, for example.
Thanks, Lorraine. I mean, you gave us one good example of a best practice in Colombia. I'm just wondering if I could go to either Ruel or Desi just to say, can you share some other good practices that you're now seeing within your own countries or regions that you could share with us?
Is it me or?
Desi? Yeah, why don't you go first, and then I'm sure Ruel will come in.
Okay, so what I could share is a good practice, probably, and this is something that I have to say, like, usually we are very negative about and critical about like what's going on in our region and in our countries. Of course, it's understandable because this is very painful for any of us, and we want improvements. But what I have to say is that in the recent years in the region, as a positive example, is the fact that due to European Union accession and integration mainly, there has been a lot of development in institutional building, which means that we have developed, established and further strengthened the institutional capacity in the field of anti-corruption, like building, establishing anti-corruption agencies, most of the countries. As you've some of the previous speakers mentioned the importance of financial intelligence units and cooperation between them. Asset recovery offices have been established in all the countries from the region, asset management offices. So lots has been done in strengthening the institutional capacity to fight corruption and asset recovery. Which didn't exist previously. Like, we could be very critical about how they function and suggest ways to improve their work. However, we have to admit that they were not in place and they were not there some years ago at all. Like, nothing has been done in this field. While now also extended confiscation regimes have been introduced in many of the jurisdictions. I have to say again, the gap between legislation and implementation is still huge, and we still have to work in this regard. But at least we have some good examples and cases. Another thing I would like to mention is the fact that the regional cooperation is improving, and I mean we have the regional anti-corruption initiative. It is a quite specific intergovernmental organization which was established after the war in former Yugoslavia. Because, and I think this is also very important to highlight, because it was established with the understanding that corruption could be also one of the reasons of even war conflicts, and how important it is to address corruption and improve regional cooperation in this field. Of course, we work more on a political level, but still, like, there are lots of positive examples. For example, the regional treaty on exchange of information for verification of asset declarations. It's a regional instrument which entered into force 2 years ago, and we are already started noticing some positive examples. So it's not that hopeless, I would say. However, we have to be also very realistic, and I mean, there is still a lot to be done.
A long way to go. Ruel, anything to add from your perspective?
Yes, from our vantage point in South Africa, historically we have tended to deal with corruption by way of, at the state level, instituting commissions of inquiry. But what is tragic about those commissions of inquiry is that all too often, until very lately with the Madlanga Commission, they did very good investigative work, wrote fantastic reports, and those reports get given to the authorities that are and gather dust. And what is a lot more welcome lately with the Madlanga Commission is that concurrent with its work of investigative work where corruption is concerned, which is so rampant, is so pervasive, it takes the form of collusion between the thugs, as it were, out there with politicians and people in power. The Madlanga Commission, concurrent with its work, it has been given teeth. Historically, the commissions had no teeth whatsoever, and they could not act with immediacy. With the Madlanga Commission, even as it is in progress, the people who are guilty of corruption get nabbed and dealt with in a manner that is a lot more reassuring now to the voting population and to the citizenry.
Right.
Now, corruption is so pervasive. You have it also in the so-called more inclined to do preventive work. I'll talk for my organization, the Institute of Directors here, of which Mevin and I have played fairly significant roles. We run courses. We inculcate, if you like, compunction and sensitivity to not doing corruption. There are training courses, there are certificates, there are also, you can also be chartered in actually subscribing to all of this. And these are also disseminated amongst corporations which adopt them voluntarily. And in the majority of cases, we have found that the work of the Institute of Directors has actually gone a long way in taking preventative measures as opposed to waiting until corruption has been perpetrated and then dealing with it post facto.
Thank you. You've all mentioned the issue of implementation, the challenges with respect to implementation. So, as you said, the laws, the regulations are there, increasingly so, but the issue is implementation. Desi, where do you see what's the primary roadblock to effective implementation from your perspective?
This is a very tricky question, and I think it's not a very difficult and straightforward answer. I mean, it's a straightforward question, but I'm afraid that the answer is not that straightforward. And I think there has been lots of analysis and researches on this. There are many reasons, I guess. I mean, initially what we believed and thought was that there was lack of institutional capacity, that we were lacking first legal framework, secondly institutions, and then that's how we've started developing them. However, it seems like that despite the many trainings and technical assistance received, we are still finding a way not to implement them properly, or not to implement them in a way that the people in the region are satisfied. And especially when it comes to the grant corruption, I mean, this is also something we have to distinguish. I would say there has been a progress with terms of corruption and fighting corruption in the region. As I said, fighting grant corruption, and there are still cases lacking, or if there are some cases. I think political will, we need more independence of judiciary as well. I mean, this is very
Right.
typical for our region, I would say.
Right.
This is the uncomfortable truth we have to face. And also, and that brings me to prevention and building integrity topic, and why it is so important, although I would say that very often it is underestimated because it's not that catchy. It's not that fancy to speak about prevention, and it requires sustainable and long-term efforts. So that you have, so because what we need is people with integrity, and also what we need are societies that are really intolerant and do not participate in corruption activities. And that's why I'm very happy as well that in our region recently we have started working more on building integrity, and also working with businesses, trying to explain that corruption is not only linked to public sector
Public. Yeah.
and what the implications and what the business could do to help us fighting corruption. Hope that this
Yeah, no,
answered your
thank
questions.
no, no,
This is very, we can speak forever, I think,
I'm sure.
about it.
Lorraine, from your perspective, what's the roadblock to effective implementation? You're on mute. You have to come off mute.
One
Yeah.
of the first things I think, and I think this is Slava has mentioned, is the political will. That is the most important thing. And when you have, and from the head of state, it should come when he sets an example of a very integral person, and that he's really against corruption, from the petty corruption to the big corruption, then because petty corruption is a way of acting in the society, which is setting an example for the grand corruption. Then everything is normal. It normalizes to bribe to the traffic police to the environmental guy who has to implement the regulations. But I think political will is the most important thing. Then, and of course, what also Slava mentioned is the institutional capacity. But when it's not a political will, and the head of state is showing that he's also corrupt, and they are showing because there is scandals in the society, then this is degrading the society at large. This is a terrible thing what could happen. And we have examples all over the world. Then that is the first thing, and institutional capacity. And of course, the strengthening of the judiciary power and the independence of it with the best people. If you put also the worst, or people that you know that are linked to the executive power, and the executive powers has problems, then nothing could be implemented in a successful way. And we have seen in many countries that this is degrading, and of course, the results are very bad, and we are not seeing progress. And the progress that have been done over the last years could really slowly disappear in this type of cases.
Thank you. So could I come to you, Roel? Because I'm just interested in this concept of ethical leadership. How do we go about creating ethical leaders, both in the public sector, but also in the corporate sector? And we'll come back. We'll probably talk about corruption, because as you said, Desi and Lorraine, a lot of people talk about corruption and they think of the public sector, but the private sector and the corporate sector also play a very important role, both as facilitators and preventers of corruption. But just maybe you could share your thoughts on how do we create ethical leaders? Ruel?
I think because corruption is so pervasive, you need to tackle it from within a framework of reform. And I want to believe that that will include a number of aspects that have got to be pursued without relenting. The first one has to do with transparency. Procurement and auditing must be open to scrutiny. It should not just be something that gets done and accepted as given. Accountability should actually be key within that framework. Institutions must have teeth. You cannot have an institution that's supposed to deal with corruption, but not imbue it or arm it with the requisite teeth to act and just mandate it and not enable it to be able to actually act. I want to believe that corporate ethics is something that should be pervasive in terms of inculcating it at various levels. Firms must embed integrity into their business models. It is not something that you do as a by the way. It should actually be embedded in their business models. Very significantly too, education should not leave out. I mean, historically, education included religion, for instance, which inculcated a sense of compunction, the pricking of conscience, as it were. But now, education has become secular. And because of this, I believe civic literacy should be in place to inculcate societies against manipulation and to make it the kind of thing that it is actually anathema and is inculcated and embedded in the culture, as opposed to waiting until people misbehave and then try to do corrective action. Of importance and relevance to what we are trying to establish now, the IACC, global solidarity is key. And I want to believe that international cooperation is vital to combat transnational graft.
I mean, a lot of people talk about ethical leadership as being something that's top down. But I also feel, and just building on what you just said, Ruel, about where it all starts in terms of education, it also has to be bottom up as well. And I've seen a lot of people on the chat during this afternoon, our time, sort of talking about the need for ethical education. It should be part of the curriculum. I think you've just mentioned something when you talk about religious studies. Do you feel, I mean, so Desi, Lorraine, please comment. Do you feel that there is a role for educators to discuss ethics early on in their engagement with their students?
Yeah, this is Lava.
I would definitely say so. Like, I mean, I don't want to repeat, and Roel and Lauren, they have been very explicit, and I do support everything that they have said. And speaking about education, what I would like also to share with you is that that young generation in our region is actually very sensitive to corruption topic. And this is, for me, very encouraging. For example, we have been very surprised to hear that according to a regional survey done in the end of last year, number one reason for the young generation to leave the region, to immigrate, is corruption, which means that young generation, and this is a red light for all the politicians, because this just demonstrates that young generation in the region is not going to tolerate it anymore. They just leave if we do not take any measures, they're going to just leave. And this creates, so they are losing voters, basically. And I think this was also one of the reasons why now anti-corruption is very high in most of the government's agendas. Again, Lauren, I would say we have to, like, one is the statements, another thing is what in practice is going to happen. But I think that this is extremely important in the long term, that we start building a society and people that are intolerant to corruption.
Thanks. Lorraine,
And this is
you were going?
probably the only thing in long-term solution.
And what a important question. And how to create ethical leaders. Because sometimes you see, and I have seen, and I know, people that have the best education, the best, we are not going to see families, but the families have values. And they were educated in the best universities of the world. And then they become leaders, and apparently they are corrupt. Then, and people know. And then people say, what is the difference between having this person that is so well educated and another one, those politicians, without so much education, but they, that sometimes they lead the countries. And that this really is disappointed. I don't believe that a leader like that, because has a very strict regulation, he will act differently. No, ethical is a thing that we bring. It's not possible that we are not going to be ethical because the punishment is big. I can't believe that. You are ethical or not. How do you create ethical leaders? And sometimes we see the best and they are not the best when they are leaders. What happened with today's values is the problem. What is the problem with greed? Why they want to have so much money, and in illegal ways? It's very difficult for me to understand, because I have had so much disappointed with people that I thought could be the best, and young, well prepared, best education, and they are acting like any other politician that we didn't hope so much. Then I think, yes, of course, civic education from the beginning, and showing to the people and any type of people why corruption is so damaging. How is damaging them? Then showing, your school could have been better teachers, better walls. Sometimes are terrible, the infrastructure of the schools in countries like us. Then could be better, and they are not better because the money was stolen by others. Then those things that you show that that they understand what is corruption, because sometimes you talk of corruption like a theoretical word that they don't understand, but how is corruption affecting them directly, and showing that perhaps you do better leaders in the future.
Yeah, thanks. I mean, one thing is clear is that the world, at least as Desi said, and you've implied, Lorraine, that the younger generation is becoming intolerant to corruption. And I know, we talk about the big scale corruption, but actually, if we address the small scale corruption first, which is what you mentioned, Lorraine, that will begin to make a difference. Can I just bring in the issue of whistleblowing? Because I've seen quite a lot of comments on that in the chat, and it was, of course, referred to in by our speakers. But do you think there are sufficient protections in place to support and encourage whistleblowers to speak up and report unethical behaviors? Let me start with you, Roel, obviously from a business perspective, because I'm sure on your boards that is an important topic that you will no doubt be overseeing as board members. So how is whistleblowing effective? Are protection sufficient? Should we be doing more, etc.?
I believe we should certainly be doing more, both at corporate level and in the public sector out there and in society. Very, very often, I mean, even as recently as yesterday or the day before with the Madlanga Commission, a prosecutor was supposed to have come to prosecute a case, but for some strange reason, disappeared into thin air. And we know what in fact might have occasioned his non-appearance. People do get murdered for whistleblowing. And that has tended to be a huge deterrent, which actually we have to attend to. There should be enough protection for whistleblowers. And I don't believe there is.
I think
Dr. Causa has frozen, Alan. I think we need to carry
we've
on.
frozen.
Thank you.
Yeah. Lorraine?
Yes, I agree with Roel that they have in any type of institute, even in the private sector, you know.
Yeah.
Then private sector.
Because that in fact they get silenced one another with mechanisms that range from intimidation to murder. So I don't believe that whistleblowers are sufficiently protected as things are, but particularly in our own country.
Mm-hmm. No. That is, of course, they are not well protected. It's very easy to know who is the one who make a claim, or there is no incentive for doing that. And then the institutions, the head of the institution, they don't want that they are whistleblowers. Then the mechanisms are not well implemented. Perhaps the laws are okay, but the mechanism for doing it and to be protected are quite weak.
Desi?
I would agree with the speakers, but probably this is something specific for our region and the European Union countries. Since whistleblowing was in focus for developing not only legislation but really effective mechanisms for implementation and protection of whistleblowers. There is a new directive from 2019 which obliges all member countries to establish effective whistleblower protection mechanisms. What we have noticed from practice at the Regional Anti-Corruption Initiative, we had a 3-year project on raising awareness on whistleblowing, because in the region, even before the EU directive was adopted, all countries in the region have a very well developed, not only legislation, but also whistleblowing mechanisms for protection. What we found out is that there is not enough awareness. People do not know that these mechanisms exist, and they don't know how they could refer to these mechanisms. So we have run a huge campaign, awareness raising campaign. And then one of the outcomes of this campaign is also the lack of public trust. So you can have effective mechanisms, you can have good legislation, but if there is a general mistrust in the institutions among the society, that it doesn't work. It's simply people just don't believe it is true. I have to say that after our campaign, the number of because we gathered statistics, the number of reports increased, and I mean, some of the anti-corruption agencies from the region were very happy about it, and even they considered to start running these awareness-raising campaigns. So I think what is important to have a whistleblowing mechanism in place, effective, is also raise awareness about, and then also follow up. I know there could be instances and cases when it doesn't work or they do not provide enough protection. But I have to say that in our region, it is not that common, thanks God. I mean, positive examples. Sometimes we also have some positive examples, but this is also very important. General trust in institution is extremely important in this regard.
Yeah, thanks. We're running against the clock, so maybe I could. Sorry, Lorraine, go ahead, please.
No. Whistleblowing is like denouncing, something that is happening. And who is doing that very well? They were the NGOs, at least in our region. And I can say, particularly in Paraguay. You know that last year, a law against NGOs was enacted by the legislative. And I know many friends who were working in very good NGOs doing fantastic work, denouncing so many things, and they have to leave the country.
Yeah.
And they have to not leave the countries, but at least set their NGOs in another country like Uruguay. Because the legislation was totally against them, and then they didn't want to have a problem with the justice, a justice that doesn't work and is not partial, is not impartial. Then that is very related with whistleblowing. Is another way of doing it. Is announcing, and those things they have been. We are not progressing. On the contrary.
Thanks, and sadly, just on the point of NGOs, I do believe that the significant reduction in international development funding, particularly for international institutions, is having a significant negative impact on the ability for international institutions to operate and blow the whistle and call governments and corporates out for their misbehaviors and bad practices. So this is unfortunately another consequence, I believe, of the significant reduction of international aid and international development. Right, we're out of time, unfortunately. We could go on easily for at least another half an hour, but unfortunately we don't have that half an hour. So thank you very much for now, and let me hand back to you, Carolyn.
Thank you so much, Alan. Thank you so much to everybody for participating, for our speakers. We've got a lot of comments on the chat, and those comments will be made available to everybody just to see what is being said. We have shared a poll, and the results are on the screen for those of you who want to see the sentiments that we have available. So the question was, does your organization have a whistleblowing facility in place, and would you use it? We've got 48% saying yes, 13% say yes, we have it in place, but I wouldn't use it. No, it's 13% as well. And so effectively you have 26% that don't have a voice. And then you've got 17% saying that no, but I would use one if we had one. And then you have 1% saying I don't think it's necessary. So we have got a sense of not needing such facilities around, and perhaps there's more to be discussed with those people to understand why they don't think that a whistleblowing facility is needed. But at this stage, and Evelyn, if you can put everyone back on the screen, I'm going to go through. We have got so many questions in the Q&A, Alan. Your conversation and the questions you were asking there has just grown the number of questions we have. If I can please ask everybody online, those questions, because we have so many, we're not going to get to all of them. Those questions that you want asked, if you could please up thumb them so that they get more votes, and then we will ask those questions that have the most votes. But one of the things that the questions that has come through is, how is this court going to be funded? And I know Judge Goldstone, you mentioned a little bit around funding, but if we could just kick off with that question, please.
Well, thank you, Caroline, for this important question. The draft statute we prepared provides that the countries that ratify the treaty the countries that come into the International Anti-Corruption Court system will obviously have to provide the major funding for the institution. And in the draft statute, we've adopted a similar process to that applies in the case of the United Nations, that countries will contribute according to their wealth. In addition, there's an additional element of funding that would arise. One of the punishments, and perhaps an important punishment that the criminal division is authorized to impose on people who are convicted is to fine them. And some of the fines could be pretty substantial, because we're dealing here with huge amounts being stolen. And fines would obviously fall into the pot and contribute to the cost of the court. Let me add, I don't think this is going to be a very expensive court, certainly in comparison to the International Criminal Court. It's going to be a much more contained and I hope more efficient system. And in relation to the amounts that we're talking about, the cost of the court really are going to be fairly insignificant. Let me make one thing very clear. There will be absolutely no question of any of the stolen funds being used to defray any of the costs of the court. The stolen funds belong to the country and the people from whom they've been stolen. And it would be absolutely unethical in all our view to in any way make those funds available at all to defray the cost of the court. So that shortly is the way we're looking at it.
Thank you, Judge Goldstone. Here's a question, and can I put this to Judge Wilson, because it is about the criminal side of things. Will the Anti-Corruption Court have strategic links with Interpol and the International Court of Justice?
My answer is a resounding yes, because we need to have those kind of relationships with any sort of entities that could assist us in following the money. So if you don't have that type of relationship, it would impede our progress. Yes.
Can I just add, Caroline? I think it'd be very important to have as good and close relationship as possible with the International Criminal Court, because certainly it's been my experience that people who contravene the law, in particular whether it's humanitarian law or international human rights law, are also people who steal. So I think there'll be an obviously a particularly important cooperation between those two courts.
Thank you. If I could pose this question to Prof. Rock, will this court be able to receive complaints outside of the nation-state channels? Could a nation-state corruption trends be aligned to investor agency ratings, for example, and hopefully a deterrent?
The business of the International Anti-Corruption Court on the asset side, in terms of the recovery of assets, will involve applications by states to get their money back. In that process, there may, as I mentioned in my presentation, be interveners who want to make a claim on the asset, whether it's an apartment building, a house, or cash or gold, and their claim can be adjudicated upon by the court. The court can look at the facts, decide whether they have an interest, and when they dispose of the property, take that interest into account. But it's fundamentally a court for member states to come forward and seek recovery of their assets. I hope that responds to the question.
Thank you, Prof. Rock. Here's a question for Prof. King. How can international organizations be encouraged to call out African leaders who don't want to take responsibility, and possibly not only African leaders, any kind of leader who doesn't want to take responsibility, point out others' shortcomings, but don't actually acknowledge their own, and discourage just quiet diplomacy, which most leaders hide behind instead of calling their fellow heads of state from wrongdoing, while we wait for this international court to be operational? So how can we hold those leaders accountable, essentially?
Well, I think becoming a member of the IACC is a positive. And a leader of a state who refuses to become a member, the question is why? And I think anyone associated with the IACC, let's say it's got a secretariat, would pose that question to him publicly and on social media and see what his or her answers are. Because one would think that he or she would be anxious to try and stop the question of looting of funds which should be used by the government for the benefit of the citizens of that country, rather than for self-enrichment of certain of the public officials. So I think with our ability to make these things very transparent today through social media, you can ask the question directly to the leader, why? Why don't you want to be a member? Why don't you want the country to be a member?
Mm-hmm. Thank you. Perhaps back to Judge Wilson. Will the International Court have any measures in place for protecting whistleblowers?
I am a good person to ask in that because I worked on the subcommittee dealing with how we could protect whistleblowers. And it's there will be a unit, or the registrar will form a unit for victims and witnesses to look after them. And falling under that as a witness would be the whistleblower. So there are lots of provisions to ensure that they are protected. We need to continue to ensure that we have, in fact, adopted the best measures, but we are working on it so that there will be cooperation with other state parties for relocation, for example. When they give their evidence, they would be anonymous initially to just protect them, and there would be a delay in the revealing their identity. So there are lots of things which we are considering to protect whistleblowers because we know they're important for the court and they need lots of protection. So that, yes, we are in fact addressing.
Thank you. Thank you, Judge Wilson. And to Dr. Causa, there's a business question here. Can people in business be supported by their business that they work for in disclosing national issues or national corruption issues?
People in business, sorry,
And so an employee, of a business, can the business help them to disclose a national government corruption issue?
Yeah, to a degree, I think that can in fact be done. We now have platforms or arenas where business and government actually come together. And you could use that arena to raise the issues. But the business that I have been with, I try to lead the charge by actually talking truth to power, where the national government chooses to be errant. So that is a risk you might like to take because you care about your political economy, you care about your nation. And I think that has got to be encouraged. We cannot just be the kind of analyst that analyzes and shares whatever it is you analyze amongst your peers and don't allow that to reach the authorities that are. I think it is important that we encourage one another, even as leaders of corporations, not to recoil at calling to book those that are in authority but are doing something inimical to the greater good. We should actually be sufficiently courageous and have the courage of our own convictions.
Thank you so much, Dr. Causa. Very, very wise words. Thank you. Alan, would you like to add to that?
No, I just wanted, in fact, Ruel said exactly what I was going to say. I think we in business have a responsibility to encourage all of our employees that work with us to care about the country in which we live. And we have a civic, almost duty and responsibility to call things out if they're not working effectively. And I think, we have a duty of care to our employees, and therefore we should always, of course, protect them, but we should also encourage them to discharge their civic responsibility to make the country a better place for them and for future generations.
Thank you. Thank you, Alan. I have one for you, Lorraine. There is, and probably to Desi as well. So there is a perception that some international organizations like the ICJ are selective in applying justice equitably or equally. So how will this court ensure that transparency in discharging justice in matters of international corruption will be equitable? Is that something you can answer, Lorraine?
I don't know if Desislava has something to say about it. But
I'm not
I think
really sure. That probably it's a question for us, probably from some of the key speakers dealing direct.
Maybe.
But we have the. I don't know if you are relating with the case of the UN and the UNCAC. Yeah, we have already the example of that, and I think this court is based in that example, and what is failing to continue the process, because not only they are the criminal part, and then how to seize the assets, and that is what this court wants to do. I think it's very important. I think the international pressure is something very important for many government, because then there are other consequences, and they have the power to do it. Regrettably, in the actual conjuncture, the international there is a regression of that. There is a regression because related to the UN, not because of the UN, perhaps that they committed some failures, but from some governments that want to reduce their power and create parallel powers. What we have seen over the last month. Then this is very damaging. I think the international organization should be strengthened. An organization like the UN should be strengthened, and also the UNCAC should be strengthened. And then we can, this court could be an addition of that, but not to do everything anew, which doesn't have sense.
Thank you. Desi, would you like to add?
Probably what I would like to add is that, yes, I agree that what we are lacking, especially in cases of grand corruption, and it's a little bit like not realistic to expect that head of states or people involved in grand corruption would fight themselves, so that's why it's very important to have an external factor to provide some pressure on this. And even for me, sometimes I think that even the existence or even the discussion about the possibility to establish such a jurisdiction is already something that can make some of our leaders think about how whether it's worth getting involved in grand corruption cases. Probably I'm a believer. I don't know, but I think it is extremely important that we discuss it and we support it, and I think that it's the only way to do it from bottom up, because it's really unrealistic to expect that top-bottom approach would work in this case. So therefore, I'm really thankful about Triple I for making it, like, for working it and for doing it. But
Thank
yeah.
you. Thank you, Desi. I've got one for Prof. Rock now. Thank you so much, Lorraine. Desi, I think you were hesitant to answer, but you had great answers that really spoke to us at our level. So an interpretation, shall I say. And one to Prof. Rock. As a civilian, is there anything we can do to support this initiative?
Yes. We're speaking today to an audience from around the world, and what we do is we encourage people everywhere to promote with their own governments the idea of getting behind this initiative and supporting it. Reference has been made to the coalition of supporters we now have among civil society, non-governmental organizations on every continent, and they meet regularly. And during those meetings, we talk about what's being done in every region of the world to promote the idea of the court, to explain how it would work, to answer questions, deal with any objections or concerns. So I guess what I would say is to become an advocate for this with your own government, with your own organizations to which you belong. There are many influential organizations that are signed on to this webinar today that are regular attendees at Good Governance Academy's events. Use your influence as part of those organizations with your government or your government representatives to increase awareness of this proposal, to promote it, to defend it, to explain it. We would find that most useful because we need that kind of grassroots support if we're going to succeed. And while I have the microphone, may I answer just very briefly the last question about how we avoid the stigma that attaches to the International Criminal Court about being unfair to certain regions of the world, whether it's right or wrong, and for one reason or another. The International Criminal Court is often accused of focusing just on one region of the world to the exclusion of the others and being unfair in its approach. That is a danger that we absolutely must avoid in the International Anti-Corruption Court. That's why we're so anxious to encourage and sign on support from all regions of the world, whether it's Latin America, Asia, Africa, Western Europe. We must have interregional support for this proposal. This is not a court for Canada and the UK and Switzerland. It's a court for the benefit of all peoples. Grand corruption is an equal opportunity affliction. You heard Justice Goldstone refer to Canada as one of the countries implicated in the oil for food scandal. Corruption is universal. It's not limited to one region. And the scope and the operations of the court must be just as universal. So we hope that because of the nature of the crimes, the nature of the issues that the court will deal with, both on the criminal and the asset side, we will be dealing with internationally, universal issues. This is not just war crimes and crimes against humanity. These are financial crimes, and it's a return of assets contested between states. So we hope and expect and will work very hard to ensure that we earn the trust of all regions of the world.
Thank you, Prof. Rock. And Judge Goldstone, you had something to say.
Yes, thank you. If I could add one point, really, if I can be subjective and speak as an African, I think one of the problems that we've come across in discussing the draft treaty with government officials is the question of sovereignty. I think African governments are more jealous of the sovereignty, and not only African government, but other former colonies. I think one of the legacies of colonialism is a fear of inroads into sovereignty. The colonial powers didn't recognize any sovereignty at all in the case of the countries that they controlled and bled. And this is something that we need to overcome. And it can only be overcome if really members of those governments, including in particular in Africa, realize that the time has come really to strengthen international law It's in the interest of smaller countries and middle countries. And I align myself completely with the call for middle powers to reinforce international law that was recently made so vividly by the Canadian Prime Minister Mark Carney. I think it's very important that this should happen. And of course, any international treaty, any country that joins an international treaty accepts to a greater or less extent some invasion of their sovereignty. They have to give a bit of sovereignty, but they only do it when there's something to be gained by doing it. And I have no doubt that joining the International Anti-Corruption Court is one of those instances where the really insignificant invasions of sovereignty will pay huge dividends to those countries.
Thank you. Thank you so much, Judge Goldstone. I'm conscious of time. I do want to leave enough time for Alan to wrap up this colloquium. We have got 10 minutes left. I'm just having a look at the agenda to make sure. Oh, I gave you 15 minutes. Sorry, Alan. So I'm not going to ask the last question.
No, Laura, Carolyn, I did send you a message in the chat, but you're so busy you didn't see it, to say, don't worry about that. I won't need 50 minutes.
Okay,
it's
great.
more important that we get as many questions out. So if you see one or two that have been uprated, please do ask them.
Yeah, there's a last one here for Prof. King. As a writer of corporate governance codes, framework standards, can a corporate governance code, and in brackets, especially one that isn't legislated or compliance requirement, make a difference when it comes to ethical leadership of organizations?
Well, I've been asked this question since 1992, when I was approached by inter alia Mr. Mandela to write a code of conduct for directors, because our fellow citizens were coming into the corporate world from which they'd been excluded during the apartheid era. And the question was put to me after the first report came out: why don't you try and have this legislated? Shouldn't the government actually legislate this? And my answer was in the negative, because my experience has been that market pressure and peer pressure, and when you are going to the marketplaces in the world for finance, for example, the question of your reputation and your personal conduct becomes critical to whether they give you the finance or they don't give you the finance. So consequently, you get market pressure building up to support positive conduct. And I think one of the best examples, let's see if my learned colleague and friend Richard Goldstone agrees with me, that in South Africa, the government in 1994 thought it prudent to legislate about how state-owned entities should conduct themselves and how they should report, and change the language of chief executive to accounting officer, and wrote a sort of line direction as to how to do things. The Public Finance Management Act. There is, in speaking to me, some of our big state-owned companies have said that they spend up to 60% on their time on compliance rather than performance. And also, they've got the sort of Damocles of 10 years imprisonment, which is the sanction for not complying, hanging over their heads. So you get conformance overriding performance. And whether you legislate or you just have it as a peer market pressure thing, which I think is better, you cannot stop someone moving from an intellectual honesty to being a rogue. No legislation in the world can change the mindset of a person. If that person decides to be a rogue and to start stealing, well, legislation of 10 years in prison is not going to stop him or her. And to this day, I think it's a very interesting exercise I did with one of our ministers. The question was, of our state-owned enterprises, how many have had a clean audit and how many have actually been conducting business on in a responsible manner and as good governors? And we could identify only 3 out of about 400 state-owned enterprises. And we then turned to the Johannesburg Stock Exchange. And he named 3 companies out of some 400 listed on the Johannesburg Stock Exchange as maybe being guilty of some form of corruption. So the JSE adopts the King Report as part of its listing requirements. And that is the extent to which I think there should be an enforcement mechanism, what I call light enforcement. And I do not believe in being legislated with a criminal sanction. I think that doesn't change a mindset, someone who wants to become a rogue.
Thank you, Prof. King. And I really need to call an end to this now, because Alan's summaries at the end of every colloquium, when you have summarized an end, has always been incredibly insightful. So I don't want to take up any more time, and I'm going to leave the summary and conclusion to Alan. Again, thank you to everybody for joining us. Thank you to our speakers, our panelists. Thank you for your time. It's been a big chunk of your time, not only out of your day-to-day, but in preparation for this event. Alan, over to you. Thank you.
Thank you, Carolyn. Sort of talking about putting me under pressure. But first of all, can I just thank all of you for joining the 15th Good Governance Colloquium today. There are still over 650 people online after 3 hours, so that's fantastic. Thank you for your questions to the panel and speakers, and for sharing your own thoughts and experiences in the chat, which was very enriching. And thank you very much for that. I'd also like to, of course, to thank our keynote speakers, Justices Richard Goldstone, Maria Wilson, and Professor Alan Rock, and to our panelists, Desi Lorraine and Dr. Ruhl, for sharing their insights in the panel discussion. I would also, of course, like to recognize the tremendous effort and the work of Caroline Chalmers, our CEO, for her tireless work over many years, leading the GA with rather limited resources, but of course with significant impact that this is having right across the world. And we see that referred to in the comments that have been coming through online. Of course, none of this would have been possible without the vision and the passion of our patron, Professor Mervyn King, who established the Good Governance Academy in 2019, and that was the start of the colloquia. Mervyn, you have provided significant thought leadership across the world. You continue to do so today, as we've seen, on important issues of governance and also, of course, on ethical behavior, both in business and in the public sector. And I personally have been inspired by your passion and your unwavering commitment. So Mervyn, thank you very much.
Thank you.
Today, we focus on the work being done to establish the International Anti-Corruption Court. And I'm sure you will all agree there is clearly a compelling case to have the IACC in place to investigate corruption and help recover stolen assets. The momentum is building, and the number of participating and supporting organizations is extensive, as we've heard. Tomorrow, Integrity Initiatives International and the convening organizations will report on the IACC's advocacy that's taking place in Africa, in Europe, in Asia, and Latin America, and on the IACC Treaty Committee's work on the next draft of the treaty. Just yesterday, and I was following this online, the UK's Deputy Prime Minister, who has been referred to by Richard earlier, David Lammy, he was speaking at the Global Partnership Conference, and he said that illicit finance and corruption are estimated to total between $800 billion and $2 trillion every year. Now, that is equivalent to 5% of global GDP. Just imagine what the world would be able to do and would be a better place if we could have 5% of additional GDP spent on citizens. This money should be in the hands of citizens supporting public services. He went on to say, instead, it lines the pockets of kleptocrats, their cronies, and funds their homes in capitals such as London. And he went on to say, together we must move beyond an agenda simply focused on transparency and ends the era of impunity for those exploiting developing nations for their ill-gotten fortunes. And I know everyone today will completely agree with what David Lammy said and has said in the past. I hope the impact of today's colloquium will go a long way in helping continue to raise the awareness of the importance of dealing decisively with corruption in all of its forms. Today, we had over 800 participants actively participating for 3 hours from more than 80 countries across all continents. So thank you very much. I look forward to seeing you all at the 16th Colloquium in November. For now, again, I thank everyone for taking part and for your interest in what the Good Governance Academy does. Please continue to support the GGA, follow what we do, and contribute to what we do, because none of us individually has all the answers, but collectively, we certainly do. And together, we can make a difference for a better world. Thank you very much, and have a good rest of the day.
Thank you, Alan.
Thank
Bye-bye.
you.
Thank you all.
Thank you. Bye-bye.